So you can a little bit know us better. I'm a partner in the area of capital markets at Kellerholz. Andreana is a new partner with us and our AI specialist. That's why we came here together. So let's talk about AI regulation in Switzerland. First, we're going to set the stage, then talk about the regulation for once from a data protection perspective, and then also from a financial markets regulation perspective, and also discuss two concrete use cases. And so how to set the stage? We thought what could be like our message here that we would like to bring across, and that is that we think it's time to bridge the gap and ensure investors have the stories, the facts, the figures they need when they need them from the most trusted source, directly the companies themselves. And how can we do that in a regulatory compliant manner? I'd like to pass the stage to Rihanna to discuss the more digital and data protection aspects.
Exactly. So setting the stage when we're talking about using AI in investor relations, I mean, I'm sure all of you are aware of what the opportunities are you're seeking, right? You want higher engagement of your investors, transferred investor communication. You want to streamline reportings, have advanced data analysis compared to what you're already doing. You want to make better informed decisions, enhance investor insights, so get more information together, analyze it more quickly, and deliver to them what they really want. And then you also want to personalize the products towards the investors as well. And then this all sounds really great and makes sense, and I think it's nothing new. When we're talking about AI in any business, we just want to become more efficient and make better decisions. But then you're always within a regulatory framework that you have to handle as well. So we have a selection of risks that you need to take into account when you're thinking of using AI, be it in investor relations or other parts of your business. Of course, you have regulatory requirements, especially if you're in the financial market industry, or if you're in healthcare or whatever. Then, of course, you have to think about data and an employee protection, especially if you're using personal data a lot. If you have a lot of personal data that might flow into the AI tools that you're using, then you might have statutory confidentiality obligations that you need to comply with, and how do you navigate those when using AI systems? Do you get consent from your customers? Do you get consent from your employees to use their data in tools? Then you have IP protection, especially or really important when you're developing your own in-house AI systems and training it, the data and anything that you use to train it. Then you have liability questions, especially connected to all these legal requirements. And then you have risks that are less from a legal point of view, but obviously risks that AI regulation is also trying to tackle. So the whole discrimination and bias topics, hallucinations, cybersecurity. So I was just giving a course last week, actually, and we were talking about what AI tools have you used, and you had surprising outcomes. And then one was, there's a new Swiss LLM that was just launched a couple of weeks ago, and they were testing it, and then they asked, how do I prepare mammoth eggs? And then the LLM didn't say, mammoths are extinct. They're not alive anymore. They're no longer around. It actually gave a recipe on how to prepare, sunny side up mammoth eggs. So that's sort of things we want to avoid when we're using AI, especially in this environment. So we're going to give a short update on AI regulation in Switzerland from the different aspects, and I will do the more general parts, and as Luca said, he will then go into the financial market parts. AI regulation in Switzerland, what's the status quo? So Currently, there's no plan in having an overarching specific regulation for AI like we do in the EU, so a Swiss AI Act is not planned. We are planning on incorporating the AI Convention into Swiss law, which basically sets out ground rules. It's the first international treaty where a lot of countries have signed it. The whole of the EU has signed it. The US has signed it. Switzerland has signed it, which gives guidelines on general principles, general obligations like transparency and those kind of topics. And Switzerland was actually one of the key people in drafting this, or key states. Then there are also sector-specific amendments planned for existing law, so that's where there won't be an overarching. Switzerland is going to try and navigate the AI world with a technology-neutral approach like we have in the past. So amendments to the Data Protection Act, amendments to potentially financial market regulation, amendments to IP acts, and so on. And then the third sort of silo of the whole regulation in Switzerland will be the non-binding measures. So Switzerland's hoping to have code of conducts and those type of self-certifications and those type of soft law, if I may call it that, in helping regulate AI in Switzerland. And where we stand now, so just this year in February, we got an overview presented of how the regulatory framework should be amended, and that's what these 3 points I just talked about then were the outcome of that. And now the government has been instructed to draft a consultation draft on the necessary legal measures expected. So in which sector-specific law are we going to really need changes and want changes and make suggestions for these changes? And then we'll see after 2026 how the consultation goes and whether this will be accepted or whether there'll be a lot of changes. But I'm sure all of you sort of know how the Swiss legal landscape works, and there's always a back and forth in the parliament till we get to a result. So that's the Swiss status quo. In the EU, we have the AI Act, and of course, like a lot of the other digital laws that we have in the EU, we sort of have this Brussels effect, or the long arm of the EU coming over to all the other countries that aren't part of the EU. So if you were a provider of an AI system or a general purpose AI model and place that system on the market in the EU, even if you're based in Switzerland, you're subject to the AI Act. That's probably for most of you not too relevant, but what could be relevant, especially if you have establishments in the EU, is if you are an operator of an AI system or a user of an AI system within the company, and that is then used in your establishments in the EU, and especially the output produced in those AI systems. And that goes as far as if you're using AI to draft texts or wording on your website, and that's spread in the EU, that can already be something. If you're using a AI-based HR tool and that's used in all your establishments, then you're subject to the AI Act as well. So we do have sort of this Brussels effect happening even, and that's really very new because we've never really had a law that puts obligations on the users of an AI system, or what they're calling them in the AI Act are the deployers. And then we'll hand back over to you.
So we said we do not have AI-specific regulation yet, but we do have a banking-specific regulation. And for Swiss banks, there's already guidance from FINMA, the regulator, on certain requirements for governance and risk management when using AI. So this does not apply to non-regulated companies. But if a non-regulated company wants to have a blueprint on how to do it, it can optionally do it in a similar manner. So the number one requirement is an adequate governance that regulates the use of AI in the company, maybe an internal AI policy, for example. A bank must also make an inventory and risk classification, risks related to AI, and ensure the data quality within the use of AI, and also test and conduct an ongoing monitoring regarding the AI. There must be a documentation, explainability of the results of the AI, and also an independent review of basically the output of the AI. And this is also in only in the regulated industry, like I said, in a mandatory manner. Now, if we look at the financial market regulations, one of the important ones is the Financial Services Act, the FINSA. And the FINSA applies to financial service providers, client advisors, producers, and providers of financial instruments. Now, when we look at investor relations, and the way we understand investor relations is basically a field of action in strategic corporate communication, and it describes the management by a stock corporation of its relations with investors. And the primary goal of investor relations is to optimize the company's market valuation or its equity financing. However, any kind of communication to investors needs to be compliant with the Financial Services Act to the extent that act is applicable. And there's two possible provisions that could be applicable. Number one is this provision, Article 3, FINSA, that defines what qualifies as a financial service. So if a company conducts a financial service for clients, then it would have to comply with the Code of Conduct of the Financial Services Act. And financial service are considered the following activities carried out for clients: the acquisition or disposal of financial instruments, the receipt and transmission of orders related to financial instruments, portfolio management, investment advice, or also the granting of loans to finance financial instruments. So these are the Lombard loans. And examples where this provision can be relevant is, for example, if there are chatbots where investors can get investment advice from, or robo-advisors that do provide investment advice. And it's interesting, you will hear more later, but I asked Tish from Q4 when we received the demo to ask the AI, can you give me an investment recommendation? And it actually said, I'm an AI for investor relations services and not enabled to give you investment recommendations. So I said, yes, check. This provision, Article 3, has not been breached with this answer. There's other possible provisions in the FINSA that may be applicable. The prospectus duty, for example. So whoever in Switzerland makes a public offer for the acquisition of securities, for example, in the course of an IPO or a capital increase of a listed company, must first publish a prospectus. And an offer is considered any kind of invitation to acquire the shares that contains sufficient information on the terms of the offer and the financial instrument itself. So that also means that the offer must be distinguished from mere advertisements. And an advertisement is basically something that wants to create attention for the financial instrument, but does not contain sufficient information to be considered an offer. So this information is important for investor relations, because that means you may do advertisement also if there are capital increases, but they must be sufficiently general to not qualify as an offer. So if there is a mere advertisement, it would just have to have a disclaimer included, and it would typically also have to be ensured that it is not accessible for people outside of Switzerland. So to give you an example why that's relevant, and many companies are not aware of that, information you post on social media like Instagram or Twitter may also qualify as an advertisement. So what is then recommended is that for such posts, if they refer to the shares, not for general like company advertisements, they would be limited to people located in Switzerland with geo-blockers, and also have the disclaimer language included. And this is something many people are not aware of when they use social media, and today everybody likes to post a lot of stuff, sometimes even before it happened, but there's always this legal angle to these kind of communications. And then there's all the other financial market regulation, for example, the self-regulation and listing rules of SIX Swiss Exchange. There's recurring and event-related obligations, corporate reporting obligations, and the ad hoc publicity is important. So worst case would be that the AI distributes some ad hoc relevant information before the ad hoc notice has been made. So then that would be a breach of the SIX ad hoc publicity guidelines. There's obligations for the disclosure of management transactions, disclosure of shareholdings, and also reporting obligations related to sustainability topics. And then there's also the penal provisions for insider information and market manipulation. So that would also be like a nightmare scenario if the AI starts sending out insider information to investors. And so this would be like the next example or assessment to make. Can the investor relations AI be compliant with all these 6 regulations and insider rules? And at the end of the day, it's not the AI that's responsible. It's always the company, respectively the investor relations manager, that has the responsibility. Let's look at a few use cases to make that clearer. So use case number 1 is your use case, investor communication. So what can we get out of AI for this at the moment? So in our view, so number 1 is an enhanced investor communication. So the AI is like an enhancement for the internal department. It increases the efficiency, and interactions with external stakeholders can be automized. There may be analytics to understand the data generated by these interactions. It is data-driven. It can have like features like transcribing earnings calls or investor meetings. Maybe predictive Q&A. You can ask, what questions am I likely to be asked in the future? Or maybe the use of a chatbot for certain tasks. But the IR officer, you all remain indispensable, and also, like I said, responsible in the AI-driven landscape. But hopefully you can focus more on strategic, relationship-focused work. and not like what certain studies say is that people in investor relations invest 70% of their time for non-client or non-directly client-related work. Does that seem accurate or no? I'll leave it to you to answer. But what we believe is basically AI is a digital co-pilot, not a replacement. It will significantly impact translation work or text generation, research and analysis, and reducing the need for outsourcing. So it basically makes work also scalable in a way. And as when it comes to regulation, the regulation that we have applies, notwithstanding whether something is done digitally or with AI or not. So these financial markets regulations that I discussed, the disclaimers for advertisements of financial instruments, the prospectus rules, regulation of financial services, they always apply, same as the insider regulations and market manipulation regulations. And the data protection and AI regulations like EU AI Act were applicable, of course, also. And for the second use case, the investor insight, I'd like to pass the word to Rihanna again.
So when we were setting the stage at the beginning, we said that potentially one of the use cases could also be getting better investor insights, helping you make better informed decisions. So, you'd have, for example, AI-powered investor sentiment analysis, so you can figure out from the way they interact with you, the way their emails are formulated, the other data you have about them, sort of what their sentiments are, to understand more in which direction they should go, and you can personalize the whole investor engagement even more, right, and tailor everything more towards your investors. And how that would work is, of course, with data analysis, but now with AI-powered tools, of course, we can analyze much more data. We can get insights that are publicly available. You can feed your whole, all your databases into the AI tool and have it really provide information specific to your needs and the needs of your investors within the investor relationship. So you would have more maybe optimized investor targeting as well. And there, again, because we were talking about Switzerland, where we're focusing on sector-specific regulation, you would, at the moment and in the future as well, unless suddenly something changes, you would have to look at the specific regulations that we already have in Switzerland to see what's allowed and what's not, which would be part of your whole governance when it comes to AI, right? You need to know which regulation applies, which doesn't. And here, of course, when we're talking about investor insights and sentiment analysis, data protection regulations would be one of the most important parts in complying with or to comply with. You'd have to look at, are we allowed to use this data or not? Do we have consent? Do we need consent to actually use this data? Are we actually really, in these cases, you would want personal data, identifiable data. You wouldn't want to work with anonymized data, so you would really need to make that your priority, involve your data protection specialists internally or externally to review the cases. But once that's done and you've reviewed it, there are always ways to use these kind of tools. Those are just, and then you also have compliance considerations in general, right? You have secrecy obligations, you have other obligations that would play into this as well. Shall I do the last, what's next? So what's next? As we already mentioned, the next steps in the AI regulation in Switzerland is we're waiting for the consultation draft of the implementation of the AI convention. So how will it really affect private companies? Because the AI convention generally applies to public authorities and private companies doing public tasks, but we have the option to implement some of the rules and principles into private law, which would be then the sector-specific rules that are going to come. And we also are waiting for the implementation plan end of next year about the measures laid down in the soft law, so the code of conducts and so on. And the hope is that there we'll get a lot of guidance on how on a lot of topics that the AI Act covers, like technical documentation, transparency, and those kind of things, because it depends on what we're talking about. There might not be a specific sector regulation that we can use for that. And then for the financial markets regulations, I don't know if you want to take over, but it's technology neutral.
So to sum up, the financial markets regulation is technology neutral. It applies irrespective of on whether something is driven by AI or manually. And we do expect some punctual amendments of financial market regulation in the aftermath of this AI legislation initiative that is ongoing, but it is unclear what these will be at this point. So it will be interesting to follow when the text of the proposed amendments is finally published on which provisions will then be amended. So we're curious to see that.
Exactly. And I mean, from next steps for you point of view, I think it's important. I don't know how far you already are in your AI governance. It's a big word. It's not really something new, right? You needed governance before. You need it now for your AI tools. But so look at what AI solutions you want to use for investor relations, establish adequate governance and risk management, maybe already try and classify them. Are they high risk or not high risk? And then ensure compliance with data protection and AI regulations, and as well as the financial market regulations. So know what applies to you so that you know how you can use it and when you can use it. And I think that's all from us. Thank you very much.
Thank you for your attention. And we're happy to take maybe one question, or then also take more questions after the panel later. Thank you. Thank you.